I don't know anything. I don't know what you're talking about.
Give your license.
I'll give you my license.
I'm going to have you come out of the car.
I'm not coming out of the car for nothing.
I promise you you're going to
I promise you I won't.
What's that?
I promise you I won't come out the car.
Are you trying to intimidate me?
No, you're trying to intimidate me. You're telling me.
Here we go.
Yes, you are.
Welcome back, everybody. I'm a law enforcement trainer instructor. I train and instruct law enforcement and military alike on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, etc. And so I'm actually, let me be honest with why I'm doing this video. I'm doing this video because I get asked so many times by both citizens, law enforcement, asking about, can a police officer order a driver, passenger out of the vehicle on a lawful traffic stop? I get this question so much. So the real reason why I'm doing this is because I can sit here and try to explain it every single time over and over again, or I can create a video and then we can reference it later. So that's actually my main motivation for this. But I think this is a good question. And this is a question that, again, I get asked all the time whenever I teach a course. I get asked this, when I'm teaching a new rookie cop, this gets brought up a lot of times. I even get asked this by veteran cops that really want to know the why, because we all have heard Pennsylvania v. Mims. So we're going to put that on the screen here for us to look at. But Pennsylvania v. Mims talks about ordering drivers out of a vehicle. It's a Supreme Court case precedence, Pennsylvania v. Mims, 1977. So the court held that when an officer has made a lawful traffic stop pursuant to in accordance with one of the various case laws on that is United States v. Cortez, meaning you have to have reasonable articulable suspicion. We're going to talk about that here in a second. But when an officer has made a lawful traffic stop, they may order the driver to exit the vehicle for their own safety. During this lawful encounter, the officer may conduct a pat-down search if they reasonably believe the individual may be armed and dangerous. The court based this decision on the principle that the safety for both the officer and the public is paramount. The court noted that the intrusion of a pat-down search is minimal compared to the potential risks faced by law enforcement officers. So, as we know, we have this called Pennsylvania v. Mims, 1977. You have the case law there in front of you. Now, something to look at and something to kind of realize during this is we have to realize that according to what we know from the Supreme Court case precedences on this, we have to first start with what is a lawful traffic stop. And again, the courts have surmised, and again, I'll put the screen here in front of you, case law, reasonable articulable suspicion. That is all that's required. A lot of people think that you have to have probable cause of a moving violation, for example, in order to affect a lawful traffic stop. Again, as you can see here, by various different courts, including the United States Supreme Court, that is not the case. A traffic stop can be conducted based upon reasonable articulable suspicion. So there is that. Those are those citations there for you there. Now, let's talk a little bit more about the safety concerns. Let's talk about that briefly. So let's talk about Michigan v. Long, 1983. This talks about, can you Terry frisk a car? The United States Supreme Court concluded that roadside encounters are especially hazardous. So let's remember that. Roadside encounters are especially hazardous, and that danger may arise from the possibility of weapons in the area near the suspect. For that reason, the court found that extending an area of frisk to the passenger compartment of a car is reasonable when there is reason to believe that there may be weapons in the vehicle. Now, I'm not stating that to go any further with a Terry frisk of a car. That's a different conversation for another day. But this is where we have found in Supreme Court case precedents, okay? So the Supreme Court has concluded, has confirmed, has affirmed that roadside encounters are hazardous, okay? We know this. NHTSA says that. The National Police Chief Association says it. National Sheriff Association says it. The FBI statistics demonstrate this. We know that roadside encounters, to include traffic stops, are dangerous. Supreme Court, again, has stated it in Pennsylvania v. Mims. And so over and over again, we have to think about this word called reasonability. And we're going to talk about that here in the future here real quick. But we have to remember that we do have Supreme Court case precedences that says that roadside encounters are inherently hazardous. So that's why I want to make that very important. That's why I think it's important that we annotate that there's a Supreme Court case precedence that, that states that that's the reason. So when we look at that, when we look at this, we also have to realize that this also includes passengers as well. So let's look at some passenger case law, again, pursuant to in accordance with the Supreme Court. So we have Maryland v. Wilson, 1997. The Supreme Court affirmed that an officer making a traffic stop may order passengers to get out of the car pending completion of the stop. The Supreme Court further affirmed that as a practical matter, passengers are already stopped by virtue of the stop, of the vehicle stop. So the additional intrusion upon them, ordering them out of the vehicle, is minimal. Again, Maryland v. Wilson, 1997. I did not make this up. This is not me, folks. Now, let's go even further with it. Okay, again, more Supreme Court case precedents. Brennan v. California, 2007. When the police make a traffic stop, a passenger in the car, like the driver, is seized for Fourth Amendment purposes. And so they may challenge the stop's constitutionality. So the Supreme Court's further saying, yes, the passengers, the driver, pursuant to in accordance with Brennan v. California, 2007, you are seized. So therefore, if a driver or passenger wanted to later challenge the constitutionality of that stop, they could, because they were seized for Fourth Amendment purposes. But also, again, in effect, that seizure would then allow you to file a grievance, but also allow them to remove you from the vehicle as already pursuant to in accordance with the case laws we've already talked about. Driver, Pennsylvania v. Mims, 1977. Passengers, again, Maryland v. Wilson, 1997. And you've heard me use this case law before, this other case law when it comes to seizure. So what is seizure? Well, the Supreme Court has defined seizure in 2021 again. What is a seizure? The Supreme Court holds that the application of physical force to the body of a person with intent to restrain is a seizure, even if the person does not submit and is not subdued. Again, Torres v. Madrid, 2021. So based upon the Supreme Court case precedences, I think it's evidently clear that a driver and passengers are seized pursuant to, in accordance with, the applicable case law that I've already presented, the fact that the motor vehicle stop is a seizure. Again, the Supreme Court has made that very, very clear. Now, there may be lots of reasons why you would want to order somebody out of the vehicle. I'm not going to get into all those reasons. But for example, one common thing, probable cause for vehicle searches. I just want to throw this out there very quickly, just for some additional context, because I think that context is important. Probable cause searches of vehicles. Police officers who have legitimately stopped an automobile and who have probable cause to believe that contraband is concealed somewhere within it may conduct a warrantless search of the vehicle as that is as thorough as a magistrate could authorize by a warrant. And again, Carroll v. United States, 1925, Brengar versus United States, 1949, United States v. Ross, 1982, California v. Carney, 1985, California v. Acivento, 1991. So again, I'm just throwing this out there to give one perspective to why a police officer may order you out of the vehicle. This is obviously not an exhausting list. There are many reasons why he would want to, but at the end of the day, pursuant to Supreme Court case precedents on a traffic stop, again, the driver is seized, the passengers are seized pursuant to in accordance with the aforementioned case laws, and also the fact that, for Fourth Amendment purposes, they are seized. So therefore, they are seized. So regardless as why the officer would want to have them exit the vehicle, they are seized, and the Supreme Court does give law enforcement the ability to order them out of the vehicle. Now, we get to the real meat and potatoes of this. What if they decide, as a driver, passenger, who have you, what if they decide, you know what? I'm not getting out of this car. Now, this happens more often than you may realize. I've dealt with this numerous times. In fact, I've dealt with this so much, I have my own template. I'm not going to lie to you. I make it real easy. For myself. I have a template on this, and that's what we're going to kind of talk about. So if I have a person that doesn't want to exit the vehicle, okay, well, what kind of things am I looking forward to next? Well, the Oklahoma statute, and this is going to be Oklahoma specific, pursuant to accordance with Oklahoma state laws, Oklahoma Court of Criminal Appeals, etc. Obstruction of an officer. So if we look at obstruction of a police officer and we really, try to get into the meat of potatoes of what this is, we have Oklahoma statute. Okay, Oklahoma statute 21540. And that states, as you can see here on the screen, any person who willfully delays or obstructs any police officer in the discharge or attempt to discharge any duties of his or her office is guilty of a misdemeanor. Nothing in this section shall preclude a person from recording the activity of law enforcement in a public area, as long as recording activity does not delay, obstruct law enforcement agent in his or her duties. Then we have the Oklahoma Court of Criminal Appeal elements for obstructing a police officer in the performance of duties. Number 1, willfully. Number 2, delayed, obstructed. Third, a specific police officer, so whoever police officer it is. 4th, known to be a public safety officer, so being able to show and prove that they're a police officer. And 5th, in the discharge of his or her office duties. And then we also have, here, I have this on the screen for you as well, we have the case law that is relevant from a state circuit that's not necessarily Supreme Court as well. In 1988, the Oklahoma Court of Criminal Appeals in Marsh v. State held that there is no requirement that a defendant use physical force against an officer before he or she may be charged with a violation of obstruction. In fact, words alone may suffice to support a conviction of obstructing a police officer, pursuant to in accordance with Trent v. State, 1989. These rulings have broadened the definition of obstruction. Okay, and again, you see here it talks about using profanity. It talks about ability to serve a search warrant, things like that. If you go further down in the literature, it does obviously say that freedom of speech is freedom of speech, and people have the right to freedom of speech. So take this for what it is. But when it comes to ordering somebody to get out of a vehicle, you absolutely have the right to order them out of the vehicle as a police officer pursuant to the applicable statutes, case law, and Supreme Court case precedents, the court of last resort. And then on top of that, furthermore, if you do subsequently charge them with obstruction, at least in the state of Oklahoma, everything here states that you absolutely can. And so it's all about, at the end of the day, the reasonableness and what it is that the law enforcement officer is trying to ascertain. In this clip, it's too short. I have no idea the reason why the officer would want them to order them out of the vehicle. But again, this goes furthermore into the reasonability of it. Now with me, we have to remember, and this is something that I don't like about what happened with this encounter immediately, or at least with this clip. You have the driver who's agitated. You have the law enforcement officer who is agitated. It's clear as day to me that they're both agitated. And it's clear to me that they're already starting to use words and they're already talking past each other. You have the officer saying, "You expect me to be scared of you?" And then the driver's like, "Oh, you're trying to intimidate me." Why don't we just turn that off? Again, I can't speak for officers. I can't speak for their conduct. I can't speak for I can only speak for myself, and I'll give myself some advice. This is what I like to do because I've been in this situation a lot of times, and we can expect to see more of this conduct as the sovereign citizen movement picks up, and we can expect to see more of this as people in modern day 2025 are going to try to assert what they believe their rights are. I expect every traffic stop I do, I expect that it could come to this. The expectation is it could happen. I hope it doesn't, but in the back of my mind, every time I make a traffic stop, I'm ready for what happens if I need them to exit the vehicle and they refuse to. And so since I've done this before, man, to me, it's all templated. I am that guy that has a template. I will grab my binder if I need to, and I will speak case law, state statutes, Oklahoma Court of Criminal Appeals. I will speak it to you. I will make sure that you're recording. I'm obviously recording with my body camera, and I'm speaking it to you because I have to understand. Okay, and I do understand that the journey does not end with the traffic stop. The journey ends when either something has been adjudicated or, realistically, if we're being honest with ourselves, the statute of limitations. At any time, I can be put forth on the stand. I can be deposed. I can have $1,000 an hour attorney ask me why I did what I did and if it's reasonable. So I don't leave anything to chance. I don't. I am that nerd. I am that geek. I am that guy. I'm unapologetic about my approach. So in the past, when I've had people that don't want to exit the vehicle when they need to exit the vehicle, and I have a lawful reason to have them exit the vehicle because, number one, it's a lawful traffic stop pursuant to in accordance with United States v. Cortez or whatever reasonable articulable suspicion or probable cause I have for the stop, I have no problem. It's kind of like basically what I'm trying to say is law enforcement needs to get better. It needs to be like Larry Bird, Michael Jordan, Kobe Bryant. They were able to go up to the best point guards, the best players in the league, the best players in the world. And any one of those three basketball players could tell their opponent, I'm going to dribble here, I'm going to do this, I'm going to do that, and I'm going to lace this shot. That's why they're amazing. That's why they're so great, because they could tell the person that they were dealing with what they were going to do, and they knew there was nothing that could stop them. As in law enforcement, we should be so professional at our job that we have the ability to ensure that we're doing everything so reasonably and so by the law and so by the book. There's nothing that's going to say otherwise for us. So for me, I have no problem letting that driver know, hey, this is nothing personal. Nothing against you. This is nothing against me. I'm ordering you out of the vehicle pursuant to in accordance with Pennsylvania v. MIMS, 1977. If I have passengers there and I need them to exit the vehicle, Maryland v. Wilson, 1997, I'm going to give you a reasonable amount of time to do that. I'm going to call for additional officers. And at that time, if you decide that you are not going to exit the vehicle, you're going to be placed under arrest pursuant to in accordance with Oklahoma statute of obstruction 21 OK 540. I want you to know the elements for obstruction is found in the Oklahoma Court of Criminal Appeals, OUJICR 6 TAC 48. First, willfully. Second, obstructing. Third, me as a police officer. Fourth, the defendant known to be a police officer, again, which is me. And fifth, the discharge of my lawful performance of the duties. I also want you to know that there's Oklahoma court case precedences, and I would read it to them. I would read them Marsh v. State. I would read them Trent v. State. I would let them know and understand. And I said, in the meantime, if you would like to take your cell phone and look up those statutes and look up those Court of Criminal Appeals and look that up, that's fine. We got time. And I just want you to know, once I do have the manning and officer coverage here necessary, we'll use the least amount of force necessary to safely extricate you from the vehicle and effect that arrest. I have no problem telling them all that. Why would I have any fear of telling them that? I'm telling them exactly what I'm going to do. I'm going to tell them the why, and I'm going to continue to give them commands numerically, consistently, in series. Sir, ma'am, please step out of the vehicle pursuant to in accordance with Pennsylvania v. MIMS. Sir, ma'am, I'm giving you a lawful order to step out of the vehicle. I'm giving you a lawful order to step out of the vehicle. I'm giving you a lawful order to step out of the vehicle. By the time we safely extricate them from the vehicle, I may have said that over 100 times. And guess what? All this is going to be annotated on my report. So whenever their $1,000 an hour defense attorney gets it, he's going to look at it. And I want a $1,000 hour defense attorney to look at my report and be like, there's no freaking way. Who is this guy? I want them to look at this and be like, there's no way. I'm good, but I'm not that good, right? Because at the end of the day, I want them to look at it and I want them to have that conversation with their client. Please tell me this police officer did not cite Oklahoma State Statute, Oklahoma Court of Criminal Appeal, Oklahoma case law, 10th Circuit case law, and Supreme Court case precedents to you. Tell me that didn't happen. Tell me he didn't also encourage you to look this information up for yourself. Please tell me that this amount of time did not pass by. Please tell me he did not give you this command 113 times in series, numerically in series. Please tell me that did not happen. No, that's what happened. I'm okay with that. That's reasonable. I have no problem getting on the stand and speaking that to truth. So again, this all comes down to the reason. Again, I don't know the reason in this clip. There are there are many reasons why a police officer would want to order somebody out of the vehicle, lawfully want somebody to order them out of the vehicle. Again, I don't know the nuances of every single case. All I can give you is just the factual reality of the world that we live in. And so here it is. I'm not saying this is my opinion. I'm not saying this is my viewpoint. This is my opinion on that case law. What I'm telling you is this is what the case law states, and this is what law enforcement can do in the reality of what we live 2025, especially here in the state of Oklahoma in the 10th Circuit. So take that for what it is. Marinate on that. Tell me what your thoughts are in the comment section below. Hope this video was helpful for you guys. And as always, long live the Republic.